Good morning, everyone. I apologize for the technical difficulties and the delay. Thanks for hanging in there. Thank you for joining today's PHCA webinar, How to Fight Back When the Deficiencies Are Insane. My name is Abby Foster. I'm the Director of Marketing and Member Services for PHCA. We offer monthly webinars to members for NAB-approved credits in order to receive updates from department staff on regulations, learn from industry experts on current trends and practices, and gain a better understanding of practical application tools to equip our members so they can continue to provide the highest level of quality care possible. Before we begin today, I have a few housekeeping items. This webinar will be recorded and made available on the PHCA website by the close of business today. The webinar has been approved for 1 continuing education credit for nursing home administrators, and certificates will be emailed before the close of today, along with a link to a survey. Please complete the survey, and if you are participating in a group setting, have each participant also complete the survey. All attendees will be in listen-only mode. However, throughout the presentation, please feel free to submit questions via your questions pane, and our presenter will address them at the end of the presentation. On to today's topic. Nursing facilities should always strive to be survey ready, but we're all human and sometimes mistakes are made. When a nursing facility receives their statement of deficiencies, they have the opportunity to dispute citations through one of the Informal Dispute Resolution or Independent Informal Dispute Resolution processes. This webinar will help nursing facilities work toward being survey ready, provide tips on how to work through with DOH surveyors when they are in the facility, and teach how to prevent unnecessary citations. It will also provide tips on when to file an IDR versus IIDR, how to write the IDR, IIDR, and what documentation to include. Today's webinar will be presented by Rob Evarts, Managing Attorney for the Lancaster Office of Kennedy PC Law Offices. Rob has an extensive knowledge and experience on this issue. Thank you for being with us and presenting on today's topic. The floor is yours, Rob.
Thank you, Abby. Good morning, everyone. Abby was being kind. I think it was my technological incompetence that led to the delay, so I appreciate everybody hanging in there. As Abby said, the environment right now is I guess unique in the 20-plus years that I've been working with nursing homes and long-term care providers, and from the regulatory oversight and compliance perspective, it is truly different and more challenging for the providers than I've seen in my career. So as I've said a couple times over the last few days when talking about this topic, I've used the term insane more in the last year than I have probably in my entire life. So let's start with that. I mean, what is insane? Insane, you know, a severely disordered state of mind. We'll skip over that one just because we don't know if DOH is listening. But let's look at the last two, absurd and extreme. You know, the deficiencies and the penalties being imposed right now, I think everybody can at least agree that they are extreme compared to the experience that we've all had in this industry. And I would argue that they're absurd as well. The information and the statistics that we had going into this change in approach demonstrated that the quality of care in Pennsylvania was actually improving across the board, and so to change up when things were actually getting better seems somewhat absurd to me and also extreme. Let's take a look at what's been happening a little bit. Now these statistics are only through the end of October of 2016. So in the first 10 months of 2016, there were almost as many licensure actions as there were in the 2 years previous combined. There were way more provisional licenses issued in 10 months than in either of the previous 2 years. And the CMPs are where it's getting really hitting home, and this is just the Department of Health civil monetary penalties. In 2004 or 14, excuse me, there were $60,000 in total CMPs issued, with an average of about $5,400. In 2015, it went up, but it was more numbers at that point. It was really only bumped up about $30 per CMP on the average, for a total of $170,000. And in 2016, the first 10 months, it jumped up $3,000 on average per deficiency. The numbers went up, and the total was more than had been imposed in the previous 2 years combined. And now, remember, again, that's only the first 10 months of 2016. Why is this happening? Well, the Attorney General suing various providers, and we won't get into the use of an outside law firm to assist with that process. It's just an ongoing quest, I guess, or witch hunt, depending on how you look at it, from the Attorney General's office trying to, I guess, enforce the laws of Pennsylvania and really push the issue. The Auditor General's office issued a report in July of last year. What I find very interesting is that the Secretary of Health actually requested this report. The Auditor General's report came out with more recommendations than they had in any report since he had been in office. And apparently the Secretary of Health is taking these to heart and trying to implement them, and one of them is increased regulatory oversight and increasing the penalties on long-term care providers. There was also a Quality Improvement Task Force report issued in September. This is actually fairly decent reading, because this is where it says, you know what, care was improving, and the statistics backed it up. They still had some suggestions, but they were helpful suggestions versus punitive, and I think this was the proper approach, but it still led to the increase in activity by the Department of Health from an oversight perspective. So, I haven't told you guys anything you haven't heard already or haven't experienced personally. Let's get into what's going on. And the question is, when should you act? Well, now, because the sooner you guys do stuff and take steps to protect yourselves, the progression of compliance and penalties will stop, or at least slow down, and it will reduce the expense and it will reduce your exposure to the penalties. I'm going to run through several things that you can do. There's traditional methods, which I'll run through quickly. This is just the oversight, or the overview of what we're going to talk about for the rest of our time, and then I'll leave time for questions at the end. Traditional methods: improve your complaint grievance process, ramp up your documentation training and oversight, challenging the surveyors before, during, and after the survey. We'll talk about IDR and IIDR, and fighting the licensure actions. So, what traditional methods can you use? First and foremost, if you guys give excellent care, your chances of facing regulatory deficiencies are significantly reduced, obviously. Screening prospective residents and their families, customer service to build trust and loyalty, and remember that customer service isn't just an external thing. It is for residents and their families, but it's also got to be internal amongst and between the staff and the administration. All of these, all the traditional methods are within the control and boil down to how a facility is managed. So, excellent care, this is always the goal. As Abby said in her introduction, the key to achieving excellent care is you and your staff. There's an exponential reduction in the chances of being cited by DOH when the care provided is excellent. And so, that's number one. Just do a good job, take care of your residents as best you can, and it helps your chances dealing with DOH and CMS. But we also know that stuff happens. So, you can have one-on-one care for all your residents, which I know you don't, but stuff is still going to happen. So, screening. I know this is somewhat of a luxury, but at the same time, if you can prevent a problem before it happens, then this is one method to use. And you should be screening your residents, or your prospective residents, excuse me, for both physical and psychological needs, at least at the time that they're looking to enter your facility. Can your facility meet their needs, both on the physical and the psychological spectrums? And if you can't, then, if you have the ability to say no, say no. One of the areas that I always try to get our clients to look at is the family or the friends, loved ones of a prospective resident. Do they have realistic expectations? If someone's been falling at home and that's why they're coming in, do they expect all the falls to stop? If someone's failing from a cognitive standpoint, are they looking to you and your staff to make someone's Alzheimer's be reversed? So do they have realistic expectations of what is going to happen when the resident is admitted to your facility? And let's be honest here. You can really kind of get a read on people pretty quickly. Are they challenging you? Are they difficult to deal with during the admissions process? Are they complying? Are they signing the documents they need to sign? Are they agreeing to assist with Medicaid, eligibility, whatever the case may be? Are they challenging you and the system, right from the get-go? And again, if you have the ability to say no to a resident whose family looks like they're going to be a problem, then I would strongly suggest you say no, because it's not usually the resident who's calling in complaints to DOH. It's family, friends, loved ones who have unrealistic expectations and just are looking for a reason to complain, and if you're not hearing their complaints, then they're going to call DOH. And even if you are hearing their complaints, they're going to call DOH. So take a look at both the resident and the family before they get into your facility. Customer service. This is, the whole idea here is to build up the trust and the loyalty with your residents, your families, and your staff. It's external and internal. What's the admissions process like? Is it easy? It's never easy, but do you make it as easy as possible? Do you smile when you see them? Does everybody on your staff smile? Do they greet residents? Do they greet the families? How are complaints of the family or resident dealt with? What happens when there is an adverse event? Because there's always an adverse event. My mother went into a nursing home several years ago with Alzheimer's, and my father is a orthopedic surgeon, used to being in control, and within the first week of my mother being admitted into the nursing home, she tipped out of her chair and slid across the rug and got rug burn across her forehead and her nose. It was a challenge to get my dad to come back down to earth, and yet they dealt with it very honestly and upfront, and my mother was leaning over to pet her dog, even though her dog wasn't there, and just tipped out. And it wasn't anything that anybody did wrong, and they adjusted things and took care of it. And my dad ended up loving the nursing home and now lives in the independent living section of that same facility, or CCRC. Internal. This is where it all starts. Do you treat each other with respect and kindness? Because if you're not treating each other with respect and kindness, then how do you expect everybody to treat others with respect and kindness, particularly the residents and their families? When you're looking at this, consider administration to staff, staff to administration, and staff to staff interactions. This is, a huge step to figuring out how to provide the best customer service. And honestly, we all know that there are staff members, sometimes current, sometimes former, who contact DOH and call in a complaint. And the more trust and loyalty you build up within your facility with your employees, the less likely that is to happen. And the culture is vital to all of both internal and external, and it has to be something that really permeates from the dishwasher, nurse aide, all the way up through into the administrator and the regional managers, etc. So if you build up the trust and loyalty, the less likely either residents, families, or your staff are going to be to call DOH and call in a complaint. You're trying to create a relationship with residents and families that is based on mutual trust and respect. And especially the families who are facing putting their loved one in a nursing home. Many times that's a very difficult decision, but if you build up that trust and respect and have the customer service to create a loyal relationship, it will kind of bubble over into other areas, and you're going to improve your market share. You're going to have fewer complaints. You're going to have better employee satisfaction, resident family satisfaction, and you're going to be able to recruit better employees as well, because we all know it's a small industry and everybody talks, and if somebody's working at nursing home A and they're getting treated like a dog, and they're talking to their friends who work in nursing home B where there is this mutual trust and respect, they're going to leave nursing home A and go over to nursing home B if they can. So customer service is the underpinning to really a lot of the traditional methods, including providing excellent care, that will help you battle back or fight off regulatory deficiencies. The majority of the surveys conducted by DOH are the results of complaints. And when they come in on a complaint, DOH isn't limited. If they see a deficiency in anything, they can cite it. So they may get a call, a complaint about the food, and they come in and they see a side rail that is, the spacing is off. They can cite you for accidents and hazards. So you just want to keep them out of your facility as much as possible, because once the compliance cycle starts, it can be hard to stop. And if you're getting numerous complaints, it also just builds on itself. You may only get, you may get a C or a D, but if you're already in the compliance cycle and you can't get out, and you get to the 90 days that you haven't gotten into substantial compliance, then you're going to end up with a denial of payment for new admissions, etc. And for all we know, DOH could start imposing civil monetary penalties for deficiencies at scope and severity level below G. Never know in today's environment. So what's your procedure? Does it vary by issue? Does everyone know the procedure? And that includes residents, families, and staff. And does it vary by issue? Does it mean, if there's a care issue versus a cleanliness issue versus a food issue, are there different procedures for different issues? And what you need to do is make sure that everyone is aware of it, and what they need to know is who hears the complaints, what's going to happen with their complaint, or what happens next, where is the complaint addressed? Is it addressed by the person who hears the complaints, or does it get bumped up the line? When should they register a complaint? Why should someone register a complaint? And my answer is anytime they have any questions or concerns about something. And then how is the complaint resolved and communicated back to the individual who registered the complaint? And there can never be any retaliation, whether it's against a resident, a resident's family, staff member, whomever. If that happens, then everybody is going to be afraid to complain or file a grievance, and they're going to need an outlet, and that outlet is DOH. So it's just vital that everybody knows exactly what's going to happen, how it's going to happen, and what the outcome is going to be. I'm not saying that you have to change something every time there's a complaint, but people need to know that they're being heard and need to know what happens after they've been heard. The majority, I don't know about majority, a lot of the deficiencies that I'm involved with, both from an IIDR, appeal, plan of correction standpoint, are the result of poor documentation. The care was provided, but it wasn't documented, or at least it wasn't documented accurately. If you're providing the care, and we all know that the vast majority of you, or of the nursing homes in Pennsylvania, provide outstanding care, and documentation may kind of be the last thing anybody wants to do, and kind of leads to some problems. So you got to increase your training. You might consider bringing in some outside experts to do training, to do help with your staff to make sure that they understand what needs to be documented and when and how. And you also need to increase your oversight. Do spot checks. Do, up and down the line, have the nurses checking to make sure that the aides are putting in the ADL assists in the record, and have the charge nurse checking to make sure that the med passes are properly documented, and have your DON checking to make sure that the charge, up and down the line. But if people know that they're going to have their documentation reviewed and looked at, and it doesn't have to be a punitive thing, but it is just a reminder that people are going to be looking over their shoulder and doing what needs to be done to make sure that documentation is there. Challenge the surveyors before, during, and after the survey. And it's not risky. If you do it correctly, you don't have to get into a screaming match with anybody, or, really, quote unquote, get in a fight, but you do need to challenge them before they show up. Have your paperwork in order. That goes back up to the documentation. Train your staff how to speak with the surveyors. It's so common in 2567s to see in the narrative for a deficiency, the director of nursing agreed that there was no documentation for X. Well, there's a way to answer that question. If the director of nursing is asked, well, there's no documentation in the chart that Mr. Jones got his meds. Well, the answer is, well, there's no documentation in there, but what about in the IIDR? What about in, point-click care, etc.? If there's any way to avoid an admission of quote-unquote guilt, that's how you need to respond to those questions. Be prepared with your policies and procedures that are updated, etc. Keep a running list of what I call target residents. The antipsychotic medications are a hot button right now. Always wander risk residents, fall risks. Keep an idea of which of your residents are going to be those target residents before DOH shows up. And if you're doing spot checks on the documentation, on the charts, you might want to make sure that you're kind of focused on some of these target residents. and you got to know the regulations, both the old ones and the new ones. We're kind of in that weird time period where events may have happened when the old regulations were in place, but now they're citing under the new regulations, and it can get a little confusing. There's a lot of assistance out there on the internet with a comparison chart between what regs have changed, when they changed, and what the changes are, so that you can track it and be aware of what has changed. But the bottom line is you need to know the regs because you guys need to comply with them. During the survey, be prepared for confrontation. And this goes back to how to speak with the surveyors. They may not like that you're not just, or your DON or your staff is not admitting that there's no documentation or whatever they're trying to get them to admit. And they're going to push it a little bit. You don't have to be angry. You don't have to be nasty. You just can stick to your guns. Provide more than they ask for. If they ask for, documentation on X, give them X plus 1. Be prompt. Don't admit to anything unless it's absolutely, set in stone. And keep documentation of your communication, verbal, and keep copies of everything that you provided to the surveyors, so that if there is a question down the line of whether something was provided or not, and if there's an IIDR, then that's what you can refer back to. Afterwards, I just talked to a client who, during the survey, they were talking to surveyors, and there were 3 potential deficiencies. They got to exit, and there were 13. They were able to provide documentation to the field office, which knocked 2 of those off. But if during the exit you are provided with a certain list of deficiencies and you have documentation that is contrary to that deficiency, you can keep providing that. There's nothing that says you're not allowed to. Depending on your relationship with the field office, call a supervisor and say, wait a second, they identified this tag during the exit, but it doesn't make any sense, and explain what's going on, and again, provide the documentation that supports your position. And then be prepared in your plan of correction, not only to give the plan of correction, but also in certain, well, I would argue in most circumstances, if you're not happy with the deficiency as it's relayed in the 2567, put in other facts. And I'm not talking about alternative facts. I'm talking about real facts that you have documentation for that demonstrates or provides a fuller picture of the situation. You are allowed to do that, and if anybody rejects your plan of correction because there's facts in there that they don't like, then I would push back and I would start talking and calling into Harrisburg. Or you can give me a call and we can talk it through and we'll figure out where to go. So informal dispute resolution, and I apologize, I'm rushing. I'm trying to save a little bit of time for questions, but we'll crank through this. Informal dispute resolution, independent informal dispute resolution. It's a federal requirement under 42 CFR 48.331, and the process is explained in PB 44, Provider Bulletin 44, which is available on the Department of Health website. when I'm approached by a client about whether an IDR is appropriate or not, and I'm just going to call them IDR for now, you need to look at several things. One, what's the scope and severity of the deficiency? You know, if you get a B, do you really want to IDR it versus an F or, you know, God forbid, an IJ? What's your documentation look like? Do you have adequate documentation to counter the allegations that are in the 2567? And what is the language of the regulation F tag that's being cited, and how does that relate to the narrative in the 2567 and the supporting documentation? What's required? It's actually pretty simple. It's got to be in writing, and it's got to be filed within 10 days. That's real. I mean, beyond that, there are more subtle differences. For example, unless it is a substandard quality of care level deficiency, you can't challenge the scope and severity through IDR. And if it's not substandard quality of care, then the only thing you can challenge is whether there is a deficiency or not. It may result in DOH changing the scope and severity, but you can't go in and request that unless it's within that substandard quality of care group. What should your IDR contain? In the body of your IDR, I would suggest that you provide redacted excerpts from the medical record or other documents that are your exhibits to your IDR. So if there's a question about whether a medication was administered consistently over, you know, a week's period, cut and paste that section of the NAR that demonstrates that it was, and then attach the MAR as an exhibit. They have to be redacted, so if it's resident R12 in the 2567, you have to take out the resident's name and substitute R12 in both the excerpt in the body of the IDR and the exhibits. You need to apply the law to the fact. So you need to look at the regulation of the F tag and say, here's what it requires, here are the facts, this is why it wasn't a deficiency. Sounds pretty simple. It can get a little bit challenging at times, but that's the bottom line. And you need to have credible evidence and a convincing argument why the deficiency should be reversed. There should, you know, if there's any question about whether a document existed at the time of the survey or not, or, you know, there's a question about someone's credibility who is submitting an affidavit in support, then you need to look at that twice. But, you know, if you have the documentation and a convincing argument, then that needs to be included. And I want to emphasize, you got to be honest with yourself. You got to be very critical in your examination of what you have, what your evidence is, and how you're going to present that evidence to convince DOH. So now we get down to IDR versus IIDR. The IDR is reviewed by DOH personnel, and it's not supposed to be someone who's directly involved with the results of the survey. It's supposed to be sent to a different region within Pennsylvania. and reviewed by them, so that it is somewhat objective. The IIDR is reviewed by Quality Insights, who's a contractor with DOH to provide that service. They recommend an outcome to DOH, so they can recommend the reversal, they can recommend the retention of the deficiency, but the ultimate decision still rests with DOH. So DOH can either accept that recommendation or not. There's also an hourly fee associated with the use of Quality Insights. I have gone back and forth between both IDR and IIDR as to which is quote-unquote better, but I think the ultimate tiebreaker is how complex are the issues that you're challenging. And if they are complex issues, I would say go straight to DOH, because they know and understand the regulations very well. And there have been situations where the folks at Quality Insights have not fully understood the regs and the issues being addressed, and I felt like there was not a good understanding of what the arguments were. Fight licensure actions. If you do get a penalty, fight it, appeal it. Both on the state and federal levels, you can appeal to the Pennsylvania Health Quality Improvement Board. I forgot, drawn a blank on the name. And for CMS, you can appeal it to the Departmental Appeal Board, and that will be heard by an ALJ on the federal level. So that's it. We have time for questions if there are any. And I'm looking online.
Thanks, Rob. That was great. So at this time, we'll open it up for the question and answer portion. So on the right-hand side of your pane, you can use it to submit questions. And we'll just hold off for a couple minutes, and as those come in, and then we'll start answering. Thanks.
And again, I'm going to say that if anybody has any questions or thinks of something that they didn't understand or don't agree with after we're done here, I believe, yeah, there's my contact information. Feel free to give me a call or shoot me an email, and I'd be happy to talk to you or respond to your email if you come up with something after we're done here, and we can go forward from there. I apologize again for rushing through stuff, but my technologically challenged old person that I am. So there is a question here. Let's see. When the state levies civil penalties, will they take into account the financial status of the facility? For instance, federal CMPs have a financial hardship waiver for facilities that are truly struggling with profitability. There is nothing in the law that I am aware of that requires the state to take into account the financial status of the facility. However, I will say that when a civil penalty is imposed by a state, Susan Williamson and the other folks over at DOH will listen to that, and Susan Williamson has said flat out to me that it is not their goal to put anybody out of business, and that there is no reason that a conversation can't be engaged in to discuss the level of the civil monetary penalty. So it's an informal process, but I think it is something that you can address with the department before and after a civil penalty is imposed. Again, I would suggest that the earlier the better, so that if it looks like there's going to be a civil monetary penalty imposed by DOH, then you get in touch with your field office and Susan Williamson, or get somebody involved who can talk with the folks in Harrisburg to address that before the civil penalty is imposed, so it's not trying to undo what's already been done. Let's put it that way. So I guess since there are no further questions up on the website that I can find,
we have a couple more on here. I can just read them out loud if you want.
Oh, all right. Why can't I see them?
They'll be in the questions pane.
There we go. I got it.
Okay.
Do you see the political health care related climate changing with the new presidency? No. That's the short answer, because it's never politically beneficial to change things that could adversely affect people's health, especially old people. So for them to come in and say, stop finding nursing homes who are in violation of the regulations, isn't going to happen quickly. It's possible that the regs will change, but I think, especially on the state side, nothing is really going to change with the new presidency. Maybe CMS will back off a little bit, but again, I don't see that as being high on the priority list. If an issue is self-identified and addressed in copy and shows current resolution, I'm finding some surveyors accept, others don't, and issue citation. Comments, please. You got different surveyors reacting differently. It depends on which field office you're in. My apologies to anybody who's under Wilkes-Barre. Even when I was at DOH for 7 years, I spent 7 years trying to get consistency amongst and between the surveyors and the field offices, and as you can see, I failed. So it's just the nature of the beast. Human beings being involved, different human beings are going to react differently, and it's a frustrating aspect, but it is what it is. Can you give some examples of positive facts which might be included in a POC? Sure. The one that pops to mind is I had a client cited for water temperatures in a public restroom, which was actually within, it's a CCRC, it was within the footprint of the personal care home, but DOH cited them because it was at 120 instead of 110. In the plan of correction, we included the fact that it was in the footprint of the personal care home and that it was in compliance with the personal care regs, and that although nursing home residents had access to it if they left the skilled facility, it was not within the skilled facility, and that was accepted. Should we have additional concerns about a referral to the National Practitioner Data Bank? I don't know if you have additional concerns about the data bank. Where I would say additional concerns in my mind would come into play is with the increase in the immediate jeopardy citations, and even if it's not immediate jeopardy, if it falls within substandard quality of care, the administrator is automatically referred to the administrator's board on the state level, which could have licensure ramifications, obviously. And even if that doesn't result in licensure ramifications, it's still on your record, which is, you know, a burden that has to be borne for the rest of your career. So, do you think you have less retaliation going through an IDR or an IIDR instead of an IDR? I honestly don't believe that there is retaliation. I don't think retaliation on the part of the surveyors is a significant issue. Again, there may be individual surveyors who feel like they've been undermined if you're successful in doing an IDR, but in theory, when the IDR is filed, the surveyors don't even know about it unless they are requested, or unless additional information from them is requested. So if you're worried about the surveyors in your field office or in your region, then I would go IIDR, because that is purely a review of your submission and the information in the 2567. But honestly, if you submit an IDR and it's successful and the deficiency is removed, that's really the only way a surveyor is going to find out about it. If it's not successful, they probably don't have any idea that it ever happened. Historically, is the success rate better with IDR or IIDR? Again, like I said during the presentation, it really depends on the type of issue involved. If it's a relatively straightforward issue, then I think the IIDR is the route to go, because they're going to actually, they do review things, and I will give them credit that they clearly read everything and look at everything, and you can also request a telephone review or in-person review if that is appropriate. Whereas with an IDR, if it's a simple issue, they're so overworked over there, I'm not sure they're going to get you're going to get a full review. Whereas with a complex issue, I think their baseline knowledge is better, so that even if they're not as thorough in their review, they understand it better before it starts, if that makes sense.
Rob, if you want to, since we've gone a little bit over, there's a couple other really great questions, but I'll be able to email them to Rob, and any additional ones people can fill out in the survey. in the email that I'll send before the end of today, and I'll get those over to Rob at Kennedy. But we'll take a break there and kind of close out. Your certificates for this webinar will be emailed before the end of today, and a recording of today's presentation will be made available at phca.org. Again, please take time to complete the survey that's emailed to you with your certificate. And thank you again to Rob at Kennedy Law for this education. This concludes today's webinar. Thanks for your participation.
Thanks, Addie. Thanks, everybody.